LIEnette had until midnight last night to file a response of why legally Craig DeThomas's shouldn't be removed as a judge, and you're not gonna believe it. At 11:43 and 30 seconds, let's just say 11:44, SliverScam actually submitted something, and you're not gonna believe what it says. Most people are aware that the appellate courts are ready to remove Judge Craig DeThomas's for his biases, for his Damasis, okay? And for acting on behalf of LIEnette's attorney, for putting me under scrutiny of questioning, which a lawyer should have done, LIEnette should have done, not a judge, okay? And so here I have a 10-page response. So what happened is the appellate courts, the higher courts, told LIEnette that she had 20 days to respond. She had until midnight last night. And so SliverScam, her lawyer, actually submitted something. And again, we can see at 11:43 p.m. What lawyer is up at 11:43 p.m.? Why wouldn't this be submitted days before? Now, here's the big thing I want you to know. Now I have 20 days to submit a response to their response. And the funny part is, they actually cite case law that we are going to use in response because they prove our case. That's how dumb it is. Now you're going, wait, hold a second. What's this case law? It's case law that involves all the same players. Mark Feather, SliverScam, Judge Craig DeThomas's. Where Mark Feather tried to get Judge Craig DeThomas's removed from the bench, and he denied it and denied it and denied it. And so SliverScam is trying to say, hey, you let him stay on the bench before. All this proves is bias. It all goes full circle back to Mark Feather, 15 minutes. All right, let's see what we got here. Okay, page 1. We're just going to go through it, okay? Page 1. Page 1, response to order to show cause. Now, this meaning order to show cause means they're telling LIEnette they did not allow Judge DeThomas's, which is standard, to allow a judge, but they did not allow him. That's not standard. They went above and beyond, and they took his voice from him. And this is basically saying you have to show why we should not legally remove Judge Craig DeThomas's. So it says, the respondent to show cause. The respondent pursuant of the court's May 15th order to the respondent shall show cause why the petitioner for writ of prohibition, that's what I filed, the writ of prohibition, I'm saying please remove this man from this case, okay? And so writ prohibition, it is prohibiting him to sit on the bench for this case. Should not be granted states as follows, okay? Remember, should not be granted is because this is what SliverScam put in on LIEnette's behalf. Number 1, on March 1st, 2024, the petitioner filed his petition seeking thereby the insurance of a writ of prohibition from this honorable court to disqualify Honorable Craig DeThomas's, the trial court judge, from presiding over the trial court proceedings in this case. So this is point number 1, okay? And basically, all this is doing is rehashing history. SliverScam is saying, Jeremy filed a writ of prohibition to remove Judge Craig DeThomas's. That's all point number 1 does. He has to actually go back over what has happened and then say why Judge Craig DeThomas's legally should not be removed. I mean, he's pretty much 99.999% removed as it is. Then he goes on to say, on May 15th, 2024, the court entered this order to show cause, directing the respondent to show cause why the petition should not be granted. Okay, so all he's telling the appellate courts is, you told us we had to show cause. That's all he's saying. You ordered that we had 20 days to show cause. Number 3, in the trial court, the petitioner filed 3 separate motions seeking to disqualify the trial court judge from continuing presiding over the trial court proceedings in this case. The petitioner filed his motions on or about December 21st, 2023, February 11th, 2024, February 21st, 2024, and the trial court in turn denied each motion by orders rendered on December 26th, 2023, February 14th, 2024, and February 28th, 2024. All SliverScam is saying is Jeremy filed a motion to have Craig DeThomas's remove himself 3 times, and 3 times the judge denied it. 3 times. Then came the appellate court writ of prohibition. Remember, he's just rehashing history, and then he's going to tell the appellate courts the legal reason, well, legal in his mind, same reason we're going to use why he should be removed. But let's keep going. Number 4, page 2, okay? This one's a long one right here on page 2. Number 4, page 2. The trial court's 3 separate orders denying 3 separate motions for disqualification are thoroughly and exhaustively researched. Each accurately recites the factual basis for its ultimate holding. Having closely examined and considered each order, the respondent cannot claim any disagreement with the trial court's factual recitations or legal analysis. The respondent thus adopts as her own in their entirety, or, Thomas likes to say, totality, all the factual recitations and legal analysis, including citations to authority set forth in each trial court's 3 orders, and incorporates them hereby in reference. Okay, I realize you may not understand what that says. What that says is LIEnette doesn't have any money to pay me. I'm SliverScam, and therefore I'm not going to research this. Therefore, I'm not going to do the work. Therefore, what we're going to do is say, we give the legal reason that Craig DeThomasis gave in his 3 motions to not disqualify himself, that he denied, which the appellate court has already looked at those and saying 99.99% they're going to remove him because of what he said and what he did. I mean, what a stupid response. So this is a response, number 1, on LIEnette having no money, and a response on laziness, and a response on, well, we've got nothing really. We're going to try and rely on everything Craig DeThomasis said before of why he didn't recuse himself, except that's a main emphasis of why he needs to be recused, because he was breaking the law in his responses. How stupid! Okay. Number 4 was a big one. But basically what they're saying is, Judge Craig DeThomasis, he's the one that he gave us the laws. He's the reason why you should not remove him. When the appellate court is already saying he's the reason why we are going to remove him. Number 5. The filing of the petition of writ of prohibition following the denial of the motion of the disqualification of a trial court's judge should occur as soon as practical. And then they cite the People Against Tax Revenue Mismanagement, Inc. versus Reynolds. Okay? So, in other words, what he's attempting to say here, as we're going to go on to page 3, indeed, where a party having knowledge of grounds for disqualification participates in further proceedings before the trial judge without first seeking a stay or seeking an appellate review of the order denying disqualification. The court has held that the denial of a petition of writ of prohibition is appropriate. And he mentions Jackson versus Leon County elections. Okay. What he is saying is, why did Jeremy wait so long to file a writ of prohibition? Well, we didn't wait that long. We filed, number 1, a motion to remove Judge Craig DeThomasis. He denied it. Filed again, number 2, a motion to remove Judge Craig DeThomasis. He denied it. Filed number 3, a motion to remove Craig DeThomasis. He denied it. And then, after 3 denials, went for the writ of prohibition. Which SliverScam here is trying to say is, why'd Jeremy wait this long? If he wanted him removed, why'd he wait this long? The 3 motions to deny prove that he's biased and he did the wrong thing illegally. You got to understand, they're scraping the bottom of the barrel here. They got nothing. Nothing at all. Number 6. In the instant case as noted, the petitioner filed his first motion to disqualify the trial court judge on December 21st, 2023. So, yes, keep going. The petitioner did not file his petition with the Honorable Court until March 1st of 2024, a delay of 65 days. During those 65 days, the petitioner continued to participate in extensive further proceedings before the trial court judge, including but not limited to the following. Let's stop right there for a second. So what SliverScam is trying to say is Jeremy didn't file this soon enough. It's 65 days later after the first motion to remove DeThomasis that this is actually being filed. No, but what we did do is file another motion to remove, and then another motion to remove, and then finally a writ of prohibition. In other words, giving Craig DeThomasis all the needed time to do the right thing. And yet he didn't. Not at all. So SliverScam goes on to say, A, including but not limited to the following. A, filing on December 29, 2023 is notice of supplemental authority and motion to modify amended extended temporary injunction for protection against stalking and request to take judicial notice, seeking a modification in the terms of a temporary injunction to permit certain conduct which the petitioner asserted is constitutionally protected speech. All right, so he's saying, well, during this process, Jeremy said, I want everything amended and I want my protected speech back. It's constitutional. B, a hearing on January 4th, 2024, at which certain contested discovery matters were discussed and tentatively resolved. A hearing on January 23rd, 2024, at which the petitioner requested affirmative relief from the court as to various issues. D, a deposition of witnesses on February 9th, 2024, during which the petitioner, through counsel, attempted to contact the trial court judge for immediate adjudication of an id or habeas motion made by the respondent at the deposition. Pursuant to Florida Family RP, lower limit terminated deposition of the witness. Now, let's just stop right there. What he's mentioning is because LIEnette continued to plead the fifth, which you cannot do. You cannot bring a case against somebody and plead the fifth. Now, I'm sure there's plenty of you out there because I've seen plenty of the comments. You don't understand what the Fifth Amendment is, Jeremy. I'm very well aware of what the Fifth Amendment is, and I'm very well aware of where it can be and it can't be used. You're not a lawyer, so just run with it. I've got legal information being fed to me, spoon-fed to me constantly. It is illegal to file against somebody, and then when you're under your deposition, plead the fifth. You can't have it both ways. You either file and you speak, or you don't file. That's the law. All right, so a deposition of the witness on February 9th. Then we're going to Crook's deposition. A deposition of the petitioner on February 16th, 2024, during which the petitioner, through counsel, attempted to contact the trial court for an immediate adjudication of an or habeas motion made the petitioner at the deposition per the exactly same fam law, So during both depositions, because neither of them would actually tell the truth and speak, they did something that is not appropriate. You can't plead the fifth. We tried to have it immediately thrown out. Craig DeThomasis did the wrong thing. He didn't throw it out. That's why it's in the higher courts right now. That's all that SliverScam is saying. So far, SliverScam is saying Jeremy didn't file fast enough. It was 65 days later. And even then, when he was going through this whole process, there were court sessions and they didn't file the writ of prohibition yet. No, we just filed 3 motions for him to remove himself. He denied 3 motions and put us in a position we had to keep going forward. All right. Oh, baby Pepper, I got you right. Is that your toy? There you go, sweetheart. All right, number 7. The petitioner alleges that the trial court judge is so biased against him that the petitioner cannot receive a fair hearing. Yeah, there's no doubt about it. He's completely and totally biased. Judge Craig DeBiasis. There is no way I'm getting a fair hearing with this man. Yet the petitioner, after raising this allegation in an 84-page motion, continued to litigate this case actively and zealously before that very same trial court judge and continued to seek affirmative relief from that very same trial court judge for more than 2 months before seeking relief from this honorable court. All right, so we're getting back to the timing again. SliverScam is saying, it's 65 days later. They were still in court, trying to fight it in court. Yeah, of course we were. Judge Craig DeThomasis did the wrong thing. He didn't remove himself. Duh! Or maybe we should do the LIEnette thing. Ugh! Okay. All right, number 8, or page 5. We're halfway through. As noted, the petitioner filed a second disqualification motion February 11, 2024, and the trial judge court denied it on February 14th. Even the petitioner did not seek relief from the honorable court at this point. Instead, and rather inexplicably, the petitioner filed his third disqualification motion on February 21st, in which the petitioner explicitly states his third motion is based on the order denying his second motion. Pause right there so you understand. SliverScam is recounting everything that happened, and he's saying, oh, all of Jeremy's motions to disqualify second motion, third motion, was because of the response on the second motion. Of course, what the judge did, DeThomasis, was illegal. Okay, thus, instead of seeking relief from the honorable court upon denial of the second motion, the petitioner continued to press his case for disqualification before the trial court judge. Again, They have nothing here. They're scraping the bottom of the barrel. They're grasping at straws and going, oh my goodness. Jeremy, he filed a motion to remove Judge DeThomas's 3 times. Oh no. And Judge DeThomas's denied it 3 times. Then the writ came. Listen, the courts, the higher up courts aren't going to play these games with SliverScam or LIEnette. All right? This is a joke. All right? To put it in legal terms, this is extremely weak. Beyond weak. This is SliverScam showing up at 15 minutes till and 16 minutes till. Although I wish it was 15 minutes. 15 minutes, Mark Feather! It should have been 15 minutes, SliverScam! Now it's 16 minutes, SliverScam. He's got a weak. It's beyond weak. It's not even an argument. It's ridiculousness is what it is, okay? All right, number 9. It was not until February 28th, 2024, 2 days before the scheduled final hearing in the trial court, that the petitioner, page 6, filed his first and only request to stay the trial court proceedings to seek relief in the honorable court. Again, he's saying the same thing a million different ways. Jeremy filed to remove Craig DeThomas's 3 times, and then after the 3rd time, he filed to have the writ of prohibition. Yep, 3 times we gave DeThomas's the opportunity to do the right thing. 3 times he denied it. Starting to sound like Judas. All right, let's go on to number 10. The petitioner offers no plausible explanation for the lengthy delay. Dun, dun, dun. How about the judge, the biased judge, actually denied 3 motions, and we said, all right, no more. This is going to the higher courts. The delay? The delay is because the judge kept denying the motions. Listen, you know as well as I know, this is a joke, okay? This whole thing is a joke. Last minute, SliverScam right now is looking like the student coming in with his homework and going, I don't have it because my dog ate it. Except he did have something, but it's ridiculously weak and it has no substance. Okay. So he goes on to say the petitioner offers no plausible explanation why he continued to litigate the case before the trial court judge for months before seeking relief from the honorable court. The petitioner timing betrays the complete and lack of merits of the allegation. Oh, well, there is that thing that Judge Craig DeThomas made us continue to meet to try the case because he didn't do the right thing. All right, so number 11, page 6, okay? Remember, so far, SliverScam is saying anything Judge Craig DeThomas says, we say as well. And then Jeremy was late filing for this writ of prohibition. Okay, number 11. The instant case is not the first time this honorable court has direct. This is where it comes full circle with Feather, with the Thomases, and with SliverScam. Yoink! I got it, sweetheart. There it is. Look at that little toy right there. All right, there you go, baby girl. All right, so he goes on to say the instant case is not the first time this honorable court has directed the respondent's counsel to respond to a petition of writ of prohibition filed by the petitioner's counsel to prohibit the Honorable Craig DeThomas from continuing to preside over a family law matter. The respondent respectfully moves this honorable court to take judicial notice to the honorable court's records in case number 1D2022-1232, hereinafter called the Aereo case. Now, who was in the Aereo case? SliverScam, Feather, and who was the judge? DeThomas. And Feather moved to have DeThomas removed, and DeThomas denied and denied and denied. And then they went to the appellate court and said, hey, this is a major problem, and the appellate court actually denied it as well. Now, here's the whole funny part of this. This is actually proving Judge Craig DeThomas's biases, that it goes all the way back to 2022 with Mark Feather. All right. You're doing okay, sweetheart. Yeah, you're such a good girl. You okay? I know. You want to see Mark Feather too, don't you? You want to see his puppy, 7. Don't you? You're such a good girl. Such a good girl. You guys are ready for a vacation, aren't you? Mm-hmm. Oh, Barbados, 1 week.
Yep.
I'm not sure. They invited me to go with them. You're still filming, dude. We're on an angle.
Oh, sorry.
He's being a dad and a cameraman. That's the deal that we have is Pepper gets to come to work every single day. Okay. All right. Number 12. We're going to get through this, Pepper. I promise, sweetheart. But they did invite me to go to Barbados with them. They'll be gone for 1 week, right?
Yeah.
Okay. And then we're going to hit the ground running again once you get back.
Yep.
And I probably should go with you, shouldn't I?
Probably.
Yeah, I probably should. I'll think about it. All right, number 12. The instant case endangers a fair bit of deja vu. In the Aereo case, the same lawyers, Feather, SliverScam, represented a litigant before the same trial judge, DeThomasis. The same lawyers filed on behalf of their client a motion to disqualify the same trial court judge, in which they raised multiple arguments substantially similar to the arguments raised in this instant case. In other words, they said the man's biased. Okay, well, we already know he's biased. He's shown his bias. The same lawyers unreasonably delayed filing their petition for writ of prohibition for months while continuing to litigate the case actively before the same trial court judge. The Honorable Court properly denied the petition in the Aereo case and should do here as well. So Mark Feather actually filed a writ of prohibition. The appellate courts denied it, and DeThomasis stayed on the case, and SliverScam was the other lawyer. Now we fast forward 2 years. Now we're seeing an entire pattern of biases against Mark Feather, against Jeremy Hales, Randy Shockett, Doreen Ingalls, and there are other lawyers that are all reporting Judge Craig DeThomasis as well. As a matter of fact, there's a conglomerate. There's a group of them coming together, and they're going to the JCQ, and they're going other places as well, making complaints because none of them feel comfortable in a courtroom with DeThomasis. This is just mind-blowing that a YouTuber who just wants to hide in Florida is opening up and exposing all this corruption. Number 13. On the same day this honorable court rendered its order to show cause, the U.S. 11th Circuit Court of Appeals issued its opinion on Tchaikovsky versus Totten. In that case, the 11th Circuit reiterated the fundamental principle that judges have an obligation to maintain control over their courthouse. This is not a joke. Look at this. Fundamental principle that judges have an obligation to maintain control over their courtroom and over the conduct of the persons in the courtroom. Interesting. This is SliverScam literally saying that Judge Craig DeThomasis must conduct order, the thing he has not done. I mean, he's throwing this in the appellate court's face, saying, you made a decision saying that the judge must maintain and conduct order in the courtroom. They have all the video of what DeThomasis did, LIEnette did. They see the complete and total disorder, dysfunction. And here he's throwing it in their face. Can you imagine being the appellate court judge right now going, yeah, we did say that. And we're looking at this case, and I see no order whatsoever. I see nothing but disorder. Page 8. When stripped of all of its salacious and hyperbolic allegations and those portions which are nothing more than complaints or disagreements about the adverse rulings by the trial court judge, all that remains is the petition, is the petitioner's and his counsel's personal grievances about how the trial court judge reasonably and effectively applied the fundamental principle noted in Tchaikovsky. There has been no order, no conduct. And SliverScam is trying to say that Jeremy and his lawyers are just mad because Judge Craig DeThomasis, he was running an ordered court. He was in charge. It's the last thing we've seen. LIEnette has run her mouth all over this court. I have yet to speak one thing of truth in rebuttal in this case. And it's been going on over half a year now. All right, accordingly, the respondent respectfully requests that the Honorable Court deny this petition. And here's what we have. Respectfully submitted on this 4th day of June 2024, Silverman and, well, we'll just say Silverman because I got a little agreement going with some others. So I'm just going to set that aside. And then what we see as well is this is a certificate of service right here. And then this is also a certificate of compliance. And so Silverman says, I hereby certify that a true and correct copy of the foregoing respondent complies with the font requirements, bookmark, old style. Basically saying what I filed is the right way to file it in the court. So to summarize, Silverman has no money from LIEnette. As a matter of fact, he's on the brink of ditching her, if the courts will even allow it, because she has no money. And he did not show up with a defense, an argument, a show cause. What he said was, yeah, whatever my buddy Craig DeThomas has said, that's what I say. Oh, and why Jeremy wait so long to do this? Oh, and he's just mad because Judge Craig DeThomas is such in control of this courtroom. This courtroom has been nothing but out of control. And now I have 20 days to respond to their response. And it's being worked on right now, this moment, very present. And it's going to blow them out of the water.